welcome to segment 7.7, the future of patents. The purpose of this lecture is to hopefully tie together where it is that we started this course. So we've gone through an overview of each of the aspects of IP. We've looked at how it relates to companies and to sizes of companies. We've looked at strategies that companies may do as far as preparing the assets, the patent applications, as well as using the patents granted after they've actually been issued. We've looked at monetization avenues that potentially companies may also explore when they're looking at actually implementing these strategies. But that being said, we've covered a lot of ground, and the purpose of this lecture is to kind of tie it all together and ask the fundamental question: what is the value of IP? We've looked at a lot of different types of IP, but where we started from a historical context of where IP initially was being used, 1,000, 2,000 plus years ago, is that still being maintained? And not only that, but when we look at IP from a national point of view within the country, what is the current perspective and position on it, and how does that relate to international type considerations? So first off, let's discuss what is the value of IP. And we started the course again looking theoretically at whether or not IP helps ideas to surface and whether IP helps society to progress. Now, as far as helping ideas to surface, I think that you would conclude, as I have, that patents in particular assist with bringing new inventions to the public. Yes, a limited monopoly is granted to them for a time, but society as a whole is now the beneficiary of this new invention. And so does it help to surface them? Absolutely. I think additionally, it helps consumer confidence to increase, which is also for the betterment of society. And consumers obviously would relate more to trademarks, consumer confidence in a particular brand, in a product. So is that for the benefit of society? And I think you would also conclude, absolutely. If we got rid of trademarks, would our trust in what it is that we would buy would also go away. But that which we buy is dependent upon companies having sufficient incentives to disclose that which they have invented. So the entire framework of everything in our entire society is built on brand recognition and trust in that brand, trademarks, inventions that allow products to come out, copyrights that actually protect a content that is being created either in relation to inventions or to brands or just content in general. That, books, artistic works, music, all this is for the betterment of society. Trade secrets creates a process by which that which is not necessarily disclosed to society, but which is still offering a competitive advantage to companies within society, can still achieve some protection. Now, one of the questions that you can be asking is, well, does subsequent litigation actually outweigh the benefits? And that is a hard question to ask, particularly in today's society, because we are so litigation hyped, and so people, and I would say almost litigation fatigued, that many people say, well, there's so much litigation, does it really outweigh the benefits? There were a number of reports back in 2012 timeframe in which they indicated litigation has such a detriment on society, it's costing us $29+ billion a year. Really an astronomical figure. And they said, well, is there that much benefit being granted to society based off of, all of the inventions that were the result of this litigation? And that's actually is a very good question, because people are constantly asking that. We do not want to get to the point where litigation exceeds the value of all the IP that is being, in fact, created. And I think you would agree with me as well that if suddenly litigation is getting rid of all value, then what is the value of having IP? So litigation and IP are almost integral to each other. One doesn't exist almost without the other. Obviously, litigation would exist in other types of legal markets. But with respect to IP, it doesn't exist. In order to be able to assert rights to patents or trademarks or trade secrets, you need to be able to assert that right, and it grants you a right to actually sue in court. I think I have a frog in my throat. So we want to ensure that the value that society is getting exceeds any of the detriment with respect to litigation that is actually going on. So when we look at the rights that are actually being transferred to the owner, one of the questions we're asking is, what rights are also transferred to society? And with respect to patents, it's a very clear designation between patent owner gets rights for 20 years and then it goes back to society. Trademarks, we look at, all right, the owner can get the rights as long as they uses it, and as long as they use it, society benefits, namely consumer confidence also can increase and the trust can increase. With respect to copyrights, because it's a creation, that is, society benefits from creations generally. So the more creations that result, the more society benefits, the more the artists can bloom, the music can bloom, things of that nature. But the focus, so that's almost an intangible type benefit to society, rather than a conveyance of rights from one party to another. But the party there that is being granted rights would be the copyright owner, namely that they would get the rights for their lifetime and then sometime afterwards for their posterity. So when we look at the value of IP, there definitely is a need to promote innovation. The question is, can market demand provide sufficient incentive? And if the market requests that something actually be created, or rather creates a need for something to be created, that may be the basis for innovation. But if we do not have an infrastructure in place where there are incentives for companies to go through the process, and I would say also the cost of actually going through this entire patenting process, they may not see a need to actually do it. So there needs to be an economic advantage, and that's where the limited monopoly comes into play with respect to patents. Last but not least, from a theoretical point of view, do we grant rights to the person who came up with the idea or the invention? Or do we just grant rights to the party that is actually using the idea or the invention? Or do we grant rights only to the person that is actually making a product associated with the idea and the invention? So these are all different theoretical points of view. And within our framework, we want to reward the person that is actually the source of that invention. And that is why it is that the rules are set up that way. We could potentially treat rights from a contracts point of view that is more similar to property rights. That when you buy and sell or assign and transfer an asset, it is something that is exactly that. And you may be saying, well, we have been treating intellectual property as if it is a property right that can be bought, sold, assigned, etc. And that is true. However, we often will still keep the ownership. As far as the designation of the owner, there may be a chain of ownership that's associated with that. There are some that say we need to take an even more strong stance on treating IP purely as a property right rather than IP as an ownership right. And there are some issues associated with both of those. For purposes of our discussion, know that we in our framework are granting rights to owner rather than just simply treating it as some property type right. Now what if, and this is a theoretical question again, what if government gave cash incentives and awards or medals to creators and innovators rather than limited monopoly? And the problem with that is, let's say that the question is, does the government merely give cash incentives or medals or awards for everyone that puts forth an invention? Because now what you would be requiring the government to do is an analysis and a subjective analysis as to where does it make sense to actually give incentives, cash incentives, awards, things of that nature. And if there is not a very clearly defined way by which that is being granted, it almost puts, and even if it is a way by which it is clearly defined, the government now is in essence acting as the judge as to what has merit and what doesn't have merit with respect to inventions and creations. Now, how it works currently is it only goes in, for example, with respect to patents, is an indication as to whether or not it has satisfied novelty and non-obviousness and utility. With respect to trademarks, it has gone on to simply indicate, you know what, this has not existed, and the person is using it in the marketplace, therefore it makes sense to grant them some rights. But the government has never gone in and said, this is valuable, or this is not valuable. And that's a marketplace determination. And so it allows everything that issues forth from the government to be on equal footing that is then tested within the marketplace. Either consumers like it or consumers don't. Either consumers pay for that patented invention or consumers don't. Either competitors go in and see, oh, that patented invention is making a lot of money for them, therefore we should mimic it, or they don't. So it's the market that actually is kind of the ultimate arbitrator here to determine where the value is. Which, and again, I recognize that the court process is being used to determine whether or not something can actually have value with respect to damages and things of that nature, but it's the market at which this is being tested. And that allows the government to treat everything equal before it, because it doesn't determine whether or not one thing is worth more value or it looks better or is better than another thing. It is simply making as much as possible an objective determination as to whether or not something is novel, non-obvious, whether or not something in fact has been registered as far as a mark or not, and is actually being used. What if no IP rights existed today? Now there is almost a push, particularly within software engineers within Silicon Valley, that say, you know what? Our life would be a lot more simple if we simply didn't have patents. And particularly within the open source community, a lot of them feel that patents are hindering. And the question that I would respond with is, do patents actually create less conflict or more confusion? From the software's point of view, they often say, well, it just creates more confusion because no matter what I do, I'm going to be infringing. Now, and if you only looked at it from the engineer's point of view, you may conclude that it does create a lot of confusion. From the business point of view, it creates more certainty because it creates protectionable assets that they can actually protect. It minimizes the risk from a market business point of view. So from that point of view, from a business point of view, from a management point of view, and from a risk point of view, it makes sense for IP because it simply minimizes risk for companies. Now, I recognize that the market goes back and forth, and in today's patent market right now, the risk is unusually high for patent owners. 10 years ago, that wasn't the case. So the pendulum sometimes swings back and forth. That's one of the consideration that's in our system, that there is sometimes fluctuation in how things are treated. But by and large, if you look over the past 200 years, it has continued to decrease risk for companies. Now, there are others that also indicate, well, can't we just replace IP rights with contract law? And this is called the property displacement theory. It could be just a chain of contracts to every part of the creation and innovation. Now, yes, that may be true, and this would be particularly useful in an international context because now you could have a contract that would apply almost internationally between countries. But the problem is that what happens if there is an issue? Where do you actually get some type of damages or remedies associated with that? Damages with respect to contracts is often different than damages with respect to IP. Contract law often looks at putting the party in a position before the wrong had been committed. And that may be the case, but that may overlook, for example, if the real value of the IP with respect to the company, if it gave them $1 billion competitive advantage, and suddenly the other person is coming in, and yes, they only brought in $20 million as far as the dent in the market, but if they skewed the market in such a way where that $1 billion competitive advantage is no longer there, then that's a $1 billion loss. They literally have lost. So contract law replacing property law, yes, it's an idea that some are positing, but many have concluded that it probably is not going to, in fact, replace patents. So from an ethics point of view, it probably makes sense that we want to award legal protection for the creation of new ideas, innovations, designs. From a fairness point of view, we also want to give some incentives that allow innovators, companies to operate in a manner that decreases their risk. The reward for patents would be limited monopolies. Trademarks, you are able to use the mark as long as you use it. Copyrights, you get protection as long as you create. So there are incentives in place to really allow a fairness for all and to try to compare and contrast that balance of rights given to society versus rights given to individuals. The reality, taking a step back, is that intangible assets are worth more today than they have ever been. And that is, I think, something that we can smile about and say, well, that's a great thing. The value that patents, trademarks, copyrights are adding is greater than it ever has been before. Now, some would say, particularly in the patents field, patents today have never been worth as much as they are today. Now, over the last 10 years, there's been a lot of hurdles. But if you look at patents and trademarks and copyrights over the last 100 plus years, I'm very hopeful from that point of view, because IP as a whole globally has continued to, one, bolster companies and help society progress. And there's a correlation with countries in particular, those with strong patent systems and trademarks and copyrights often have very strong economies where innovation and emerging markets can really thrive and flourish. Now, nationally, property rights are guaranteed by the Constitution. I've been indicating there's a lot of litigation reform going on. Some of the things that they're looking at is that they're trying to create easier ways for patent owners to assert their rights without actually encumbering them by all the litigation costs. So, for example, a small claims type court relating to IPs, that currently doesn't exist. There's a variety of different things that they're looking at to try to make it more consistent for all patent owners to be able to assert their rights anyplace, anywhere. As far as IP environment is concerned, there's a lot of rhetoric right now. And in fact, there's even multiple bills before Congress in which they're looking at what reform would be appropriate. Does it make sense to redo everything that's occurred over the last 10 years, which some would suggest that should occur? Or do we simply clarify and change some of the bad elements that have crept into this system? They were intended to repair some of the prior wrongs, but in the end, they may have created more issues than what previously existed. Now, with some of the other things, there is definitely an increased scrutiny with respect to the IP industry in general. And there's also increased attention. And the moment that you have, for example, a multi-billion-dollar type sale or agreement, that really often is turning heads. And that's the case over the last 10 years. There's been multi-billion-dollar type deals and even hundreds of millions, if you look at Kodak, even in their bankrupt type state, where people are saying, you know what, there is value here. Even if a company is failing, there is still value here. So as a result, the increased attention, I would say, is resulting from media. Increased scrutiny is resulting from new people looking into this that had never looked at it before. So you have a lot more bankers looking into it. You have more corporate type attorneys that are looking into it. You have people that do not necessarily have a background in patents and trademarks that are suddenly trying to analyze this much more thoroughly. And I would indicate those that do not even have a legal background are trying to analyze this more. In fact, some of the top patent auction companies in the world are often staffed by non-attorneys. They are often staffed by financiers, those that are looking and evaluating markets and things of that nature. Bankers are often doing the analysis there. They obviously are becoming and are relied upon to become to be patent savvy, but the reality is that that increased scrutiny is also applied because different people are now analyzing patents. If we analyze them all from the point of view of a patent attorney, we make it a more homogeneous type, viewpoint. But suddenly we have attorneys, patent agents, we have bankers, we have the everyday lay person that is reading the Samsung v. Apple case and has their own opinions. I've heard it around the dinner table. So this scrutiny is coming from lots of different groups that normally would not be evaluating patents, suddenly having an interest and in evaluating. And this has led, I would say, to greater scrutiny, greater quality within the marketplace in general. As far as international perspectives, without IP, how would we actually protect IP source of information? Think of what our discussion was with respect to Charles Dickens or Victor Hugo. We need an IP framework in place so that one country can actually engage and talk to another country, and creators from one country have protection in another country's jurisdiction. We could potentially look at contract law or international property rights, a dispute resolution type international court. But although there's much been theoretical debate on that, nothing has occurred there. So will bilateral agreements further assist with IP type efforts? Again, there's been a lot of signing, but there's been little action. So countries will actively sign these agreements to show that we're on the same page. But behind the scenes, they may be acting in a manner contrary to that because there might not be ways to actually enforce IP provisions of these bilateral type agreements. Last but not least, how else can a company leverage its position? You can look beyond when we talk about leveraging with respect to companies, but it's often within the framework of the marketplace nationally and competitors within that marketplace generally nationally. But if you're looking at international type considerations, you can look at licensing and franchising internationally. You can look at merchandising, joint ventures. So in short, the possibilities of what you can do on as far as increasing your leverage on an international perspective increase just with the number of things that you can potentially do. Now, I think one additional conclusion, going back to our analysis of Samsung and Apple, we want to decrease favoritism, and that is where the government is favoring one company over another within its own jurisdiction. We can't live without the government involvement because they provide the framework by which all IP essentially exists. But too much of it can obviously stifle interaction between companies within a jurisdiction. So in short, I think that we would want to decrease favoritism from international perspectives so that companies can be more favorably, and I would say objectively, compete against each other. Last but not least, will foreign shopping increase? Potentially, because each jurisdiction treats IP differently. There obviously is some foreign shopping going on as to who offers the best damages, who offers the fastest courts, who offers the best judges, things of that nature. China 10 years ago was really not a known destination for patents. Nowadays, they are very much so. So, in conclusion, a need for IP, I think, still exists, both nationally and internationally. Historically, we see that IP has played a pivotal role in the emerging of countries and how it is that they have formed. In our modern context, governments provide the framework by which companies can more actively engage in this market process, and consumers that enter and engage in that market, namely buy anything, have a confidence in what it is that they are actually buying. Reform is constantly occurring, and we can always, rather than just focus exclusively on IP rights, I think that when we look at IP in general and the future of patents, we should look at how it is that in general we can increase the leverage potential of a particular party. So, and when we look again with respect to international considerations, joint ventures between one country or one company in one country and another company in another country would allow that type of leveraging potential to more effectively engage on the international sphere as well.